registered. This petition has been filed for quashing of the entire criminal proceedings, including the FIR being Sodor Choibasa PS case number 05 of 2014, corresponding to GR number 21 of 2014, registered for the offence under sections 409 and 379 of the Indian Penal Code, pending in the Court of Learning, Chief Judicial Magistrate Choibasa. In view of allowing the IA number 10859 of 2023, the order taking cognizance dated 12/09/2019 is also under challenge. The FIR was lodged by the Regional Deputy Director of Education, KOLKATA Division, Choibasa, with reference to letter number 364 dated 23/12/2013, issued by the Deputy Secretary, Human Resources Development Department, Government of Jharkhand at Ranchi. It is alleged that the petitioner was put under suspension by notification number 107 dated 15/10/2013 by the name of Regional Deputy Director of Education, RDDE, KOLKATA Division 1, vehicle bearing registration number JH01T-3926 allotted. It is further stated that the informant has been informed on the basis of newspaper report dated 24/10/2013 that the petitioner violated the order of suspension and discharged his duty by sitting in his office. In this way, it cannot be ruled out the defalcation of or misplacing the records. The petitioner has not submitted his joining in the headquarters after the suspension, nor he has stopped using the vehicle. The petitioner is absconding with the vehicle. In this way, the informant has been directed to lodge first information report, and hence the informant requested the officer in charge, Sodor Choibasa, to lodge the FIR. Mr. Tandon, learned counsel, appearing for the petitioner, submits that the petitioner was the senior-most officer of the Jharkhand Education Service on the alleged date of occurrence. He submits that at the fag of the service career, the petitioner has been harassed by the vested interest, and the FIR was registered on 09/01/2014, and the petitioner was made to retire on 31/01/2014. He further submits that only allegations are there that after suspension of the petitioner, he has kept the vehicle of the department for some time. He submits that the petitioner was suspended by order dated 15/10/2013, and the said order was challenged before this court in W.P.S number 6515 of 2013, wherein the suspension order was quashed by order dated 30/01/2014. He submits that the allegations in the present FIR and the departmental proceeding are similar. He further submits that it is well settled that if on the same set of facts the departmental proceeding and the criminal proceedings are instituted, and if there is exoneration in the departmental proceeding, the criminal proceeding is an abuse of the process of law. He submits that the case of the petitioner is fully covered in the light of the judgment of the Honorable Supreme Court in the case of State of Haryana and others versus Bhajanlal and others, reported in 1992. Sub within bracket 1 SCC 335. He further submits that the guidelines made in para within bracket V of para 102 is in favor of the petitioner para. Mr. Shukla, learned APP appearing for the state, submits that the case is real and the learned court has rightly taken the cognizance para. In view of the above, it is an admitted position that only allegation in the FIR is made that petitioner was put under suspension, and in spite of that he has used the vehicle provided to him by the department, and that allegation was also the subject matter in the departmental proceeding. Pursuant to that, the petitioner was suspended. The suspension order dated 15/10/2013 was challenged before this court in W.P. within bracket is number 6515 of 2013, wherein the said suspension order was quashed by order dated 30/01/2014. It is well settled that if the same set of facts, the criminal case and the departmental proceeding are instituted, and if the exoneration is there in the departmental proceeding, the criminal proceeding can be quashed. This aspect of the matter has been considered by the Honorable Supreme Court in the case of Ashu Surendranath Tiwari versus Deputy Superintendent of Police EOW CBI and another, reported in 2029 SCC 636, wherein paras 8 to 13 the Honorable Supreme Court has held as follows. Para, a number of judgments have held that the standard of proof in a departmental proceeding being based on preponderance of probability is somewhat lower than the standard of proof in a criminal proceeding, where the case has to be proved beyond reasonable doubt. In PS Rajyo versus State of Bihar, PS Rajyo versus State of Bihar within bracket 1996 9 SCC 1 1996 SCC within bracket CRI 897. The question before the court was posed as follows within bracket SCCPP 223 para 3. The short question that arises for our consideration in this appeal is whether the respondent is justified in pursuing the prosecution against the appellant under section 5 within bracket 2 read with section 5 within bracket 1 within bracket E of the Prevention of Corruption Act 1947, notwithstanding the fact that on an identical charge the appellant was exonerated in the departmental proceedings in the light of a report submitted by the Central Vigilance Commission and concurred by the Union Public Service Commission. Stop. Thank you.